Well, hi there. Well, hi. Welcome to my talk with you today. This is Leanne, the lawyer, and I feel like our friendship has grown so much that I'd like to share a recipe with you. When I think about preparing deeds, I think about it's like preparing a cake, right? If you want to make cake or cookies, what do? You need to have flour, eggs, or in my case, you need a box that says Betty Crocker on it, and you just add water. There's some stirring involved. But a deed is a little bit more complicated than Betty Crocker. So, what I'm going to do is I'm going to take my bowl. I got my bowl. I got my spoon. But I have what it takes to put in this bowl to make a deed. So let's talk about those things. These are the ingredients. If you don't have these ingredients, you are not going to have a deed. So think about these. When you're researching deeds, when you're looking at deeds and you're reviewing them, if it's missing any of the ingredients, then you want to start thinking to yourself, is this deed valid? Okay? So when you're preparing the deed, you're going to start out with our first ingredient, which is the caption. Okay? So the caption is the place where it's going to say the county and the state in which the grantor actually executed the deed. Okay? That is what's going to be in the caption. And usually, there's going to be the title. It's going to say deed. Okay? Very simple. That's our first ingredient. Our second ingredient is going to be what is called the preamble. Okay? Second ingredient. The preamble. And this is where the parties are identified. Okay? So the grantor is going to be identified and the grantees are going to be properly identified. And remember, if we don't properly identify the grantee, what happens? Your deed is not valid. So in the preamble is where that information is going to be. Next one is going to be your granting clause. Granting clause. This is where that language is I, the grantor, am granting to you, grantee, this property. These are words of conveyance, and they're going to be found in your granting clause. Your granting clause is going to be followed by probably your warranty clause. Okay, this is where if there are any warranties in this deed, you are going to find them. So in your general warranty deed and in your limited warranty deed, you're going to find these words of warranty. That's where those covenants are going to be. In a quitclaim deed, because there are no warranties, you're not going to find any warranty language. There won't be a warranty clause. Okay? Description. This is where you're going to have a legal description of the property, and it's very important that, whether it's meets and bounds or it's platted survey or whatever, it needs to be in there, and that's going to be the description ingredient. Next ingredient is called the Vendome Clause. That's Habendum, Habendome Clause. In this clause, it says exactly what is being transferred, how much interest is being transferred. Sometimes people aren't giving everything. They aren't giving the whole property. So your Habendum Clause is where you're going to look at it and identify exactly what is being transferred in this deed. Habendum Clause is very, very important. And last but not least, your final ingredient is your testimonium. Okay, and this is where the signatures go. And remember, in a deed, the grantee does not need to sign. The grantor is the one who signs. And if the grantor is married, then you also need to have the spouse's signature. All right, well, there we go. We just made a deed cake. I'm sure it's delicious. Yummy. We lawyers. Okay, see you next time.